Assalamualaikum warahmatullahi wabarakatuh. So I bid to all, everyone here, and welcome to Dr. Amin, our lecture. So we are from Group 1. We are going to explain and present about the topic of application of international law in ICL under Rohingya case. So this is my group member. The first one is Syafiqah is here. Me myself, Ammar Izzat Rizal Huzairy. Noraini binti Aliudin, Anifah Nazira binti Daeng Affendi, and lastly Aisyah Imanina binti Jamizi Rizan. So we move to next for the introduction. Pass to the next member.
So first of all, our scope and limitation is we focus on the application of international law for genocide from year 2016 until 2019. Next. Okay, so for the introduction, first of all, international law is established the modification and development of world system founded at independent sovereign state in both practice and also conceptual understanding. The earliest structure of international law was developed out during the European Renaissance and interlinked with the growth of Western political organization at that time. So the development of European concept of sovereignty and nation state required the development methods for interstate relations and standard of behavior in the making of international law. Next. The Rohingya is one of Myanmar's ethnic minorities. The number of Rohingya Muslims have the largest percentage of Muslims in the Myanmar majority in Rakhine state. Discrimination of Rohingya is the policies of Myanmar's government since 1970s, forced big number of Muslim Rohingya to run away from their home in the Buddhist countries, for example, through restriction on marriage, education, religious choice, and freedom of movement. In the August of 2017, the government claimed Arakan Rohingya Salvation Army, or also known as ARSA, as a terrorist organization and launched a brutal campaign which affected hundreds of destruction of Rohingya village and forced them to leave Myanmar. Next. International criminal law can be defined as a body of public international law that initiates individual criminal responsibility for international crimes. For instance, war crimes, crimes against humanity, genocide, and also aggression. To make it short, criminal law is an act of violation against international community. Individual criminal responsibility and violation of international humanitarian law also considered as international crime. Now, criminal law works through international and ad hoc tribunals, hybrid tribunals, and also International Criminal Court, ICC, as well as national courts. So lastly, the fact-finding mission has filed killings, sexual and gender-based violence, forced labor, forced recruitment of soldiers, and torture towards Rohingya. So next, I will pass to the next presenter.
Okay, for the first objective, we examine how international law is regulated under the ICL in Rohingya cases. Next. The United Nations Human Rights Council has established a commissions of independent fact-finding inquiry into the Rohingya cases, into the Rohingya crisis, which recently released a report detailing the atrocious atrocities perpetrated against the Rohingya committed by the Myanmar army, which is the Tatmadaw, like massacres, sexual and gender-based brutality, slave labor, false recruiting of soldiers, and torture throughout the Myanmar. Next. The ICJ provisional measure orders are legally binding toward its parties. Therefore, Myanmar, as the signatory of the Genocide Convention, could held responsible for their actions if there are any contracting parties to the International Court of Justice, which is the ICJ, under the Article 4, bring a genocide allegations up against the Myanmar before the ICJ. A genocide claims before the ICJ would have relevant for three reasons. First, the ICC can emphasize individual criminal responsibility, while the ICJ will pursue legal accountability at the state level and compel Burma to respond explicitly to the allegations against it, in which it has so far declined by before the ICC. Second, the ICJ could also issue A provisional measure direct Bangladesh and Myanmar to delay their agreement to repatriate the Rohingya. Though Myanmar does not comply with this measure, Bangladesh, which has cooperated with the ICC, may be more likely to do so. Such relief will be crucial for Rohingya refugees who are terrified of returning to the Myanmar. That claims of genocide are also by far the most serious allegations against Myanmar and cannot go unpunished like that, particularly in light of the international community inaction. That's all.
Okay, so for the next objective, objective number 2, the relevancy of international law in 21st century. Okay, so this Rohingya crisis is a long-standing conflict of the Rohingya that show the international law is weak and not entirely convincing. So the main actor to this particular issue, which we can refer back to the main body, the legal body, which is the United Nations, as the international body, have to play their role in this matter. So how to solve this? How to make the law relevant back? So the cooperation between states, particularly in the UNSC, United Nations Security Council, the partner member at the global level, which is they must cooperate and be pluralist to allow the peaceful coexistence, so that this will in line with the Article 2, Clause 3 in the United Nations Charter. So the scope of relevancy, we can refer back to the two international judicial organ, which is the ICJ and the ICC. Okay, so for the ICC, International Criminal Court, the pre-trial chamber finds that the court may exercise jurisdiction over the crime of cross-border deportation of Rohingya, even though the alleged crime has been committed in Myanmar, which is they are not a state party. But then Article 12, Clause 2 and Clause A of the Rome Statute stated that the state on the territory which the conduct in question occurred. So this article, the particular refer to the words, the interpretation of the word conduct, which the word conduct giving a broad term includes the consequences of the act. Then we move to the ICJ, International Court of Justice. Since Myanmar is a signatory to the Genocide Convention, as we know, Genocide Convention is an international treaty that passed by the UN. So Gambia conclude that they stand this convention under part of erga omnes, this legal mechanism which mean towards all. So all states have to honor, have to bind to that convention. So this treaty mentioned that any contracting party to the treaty approve the ICJ's jurisdiction under Article 4, they could bring a genocide claim against Myanmar before the ICJ. So it is a dispute between state and state. So in this case, it's Myanmar against the Gambia. And lastly, for the role of the ICJ, this means to seek legal accountability of the state level, which in this case is Myanmar, compared to ICC, where, as we know, the jurisdiction is focused more on the individual criminal responsibility. So next for the objective number 3.
Okay, we're moving on to objective 3, which is the challenges of application of international law in settling dispute. Next slide, please. So the first challenge that international law faces is lack of trust on both sides. In the case of an ICC investigation, it would most likely to face many hurdles, as there would be a lack of cooperation from the Myanmar government. As it is well known, Myanmar is not a party to the Rome Statute, of which established the ICC. So the court technically does not have jurisdiction over crimes committed within Myanmar's territory, or unless it is authorized by the Security Council. Next challenge is the ICC cases takes a long time to prepare and prosecute. The ICC would only focus on a narrow set of crimes not representative of allegations of violence across Myanmar. The investigation process will be confidential, meaning that all developments and arrests that is done will take time to materialize. Next slide. So at present, there is no existing body of international law enforcement, nor there is also no strong political support for creating such a body. The enforcement mechanism frequently stated in the news is the United Nations Security Council. Under the provision of Chapter 7, the Security Council may determine the presence of any threat to the peace or act of aggression and force necessary sanctions to try to amend the state. So in the end, it is seen that the enforcement tools of international law are flawed. Next, please.
Okay, for the criticism and comments on the application of international law on the Rohingya issue. So, as we all know, United Nations Security Council has failed to take action because it was hindered by Russia's and China's use of their veto powers. So, the United Nations Security Council has visited Myanmar and Bangladesh and also issued a non-binding presidential statement. But however, the two permanent members, which are Russia and China, has threatened to veto a resolution and rejected on any kind of resolution passed by United Nations Security Council, primarily because they are Myanmar's allies and has some political interest with Myanmar. The second criticism is that as Myanmar did not join the Rome Statute of the ICC, the court has limited jurisdiction over the crimes committed in Myanmar. But there is an exception, where the ICC can exercise its jurisdiction only if the UN Security Council would decide to request the ICC to initiate investigation. However, there are serious barriers to any effort to prosecute the possible perpetrators before the ICC. Before the ICC, due to lack of access on the Myanmar territory and the government refused to give cooperation. So the limited scope and possible findings of the investigation has made it impossible for the Office of Prosecutors to bring charges against individuals responsible for international crimes against the Rohingya in Myanmar. So the next one is the failure of ASEAN to encourage Myanmar to take responsibility for the crimes due to its non-policy of non-interference. So the difficulties to seek justice for the victims and accountability for the crimes committed has shown that in this part of the world, the this also shows that in this part of the world, human life continues to be lightly viewed by the international institutions, and the justice for the victims is being put aside in favor of profitability and the ideology of non-interference by ASEAN. This policy has resulted in a regional segregationism, which are the protectionism from human rights approach that does not facilitate quick and effective relief from the milestone of atrocities and genocides. And regards to this, ASEAN has unfortunately continues to stick to its policy of non-interference and consequently has denying the Rohingya communities from getting the justice they genuinely deserve. So for the conclusion, to sum up our research on this issue, basically there is no long-lasting progressive changes made despite the international community effort to reach a settlement on the issue of Rohingya. So the ICC and UN Security Council act on behalf of the ICJ itself, has faced with challenges to start investigation due to the new policy of Myanmar, which is to limit the foreign and outside intervention. Besides that, despite the decision of the ICC to open the investigation on the Rohingya, as on having the compatibility with the international law, the failure of the ICC members to refer the case to the court has illustrated their ignorance on regards to these genocide crimes. This goes the same with the ICJ, which is they also has failed to have effective formal action to resolve the crisis. However, any negative opinions on the ICC and ICJ must be put aside in order to better solve this humanitarian crisis. It must be understood by the world leaders that the issue here is not the incompetency of the ICC or any other international legal bodies, but it is about the inadequate support and assistance by the international community, which has made the ICC as the court of last resort to settle this issue. So that's all from our group. Thank you.